Stay in the hallway. You're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Justice Serve TV is on the air and a little bit out of focus here. Hello, Linda Kenney Baden. How are you?
Michael Bryant, I just got a notification on my iPhone that we're on the air because you know why? I hit that subscribe and that notify button, which is
And what about the like button?
It's not there right now.
I think it pops up. It pops up on replays. I don't know if it's there when we're live.
Yeah, when we're live, it's not there.
Hit the like button. That's what I understand is good. Hey, look what I have. These are the motions that were just filed.
I refuse to waste another printer cartridge.
No, this is just a prop. This is the prop.
Oh, you just prop.
Just a ream of paper.
A lot of these motions are just props too.
I know.
Really interesting because today, ask me what I did today most of the day. Besides,
what'd you do today most of the day?
Well, I had to read briefs that were filed in the U.S. Supreme Court about RICO on a case that could affect the case of mine, and I wanted to read the briefs on the certiorari. That's what it's called when you apply to the Supreme Court to take a case, and then it was argued, and I wanted to read the argument and all, and then, okay, not only was that a lot. In Karen Reed, all this stuff dropped from last night to this morning to we haven't even talked about the media order.
That's kind of a throwaway, but we should talk about it. And I will say right now that I've been watching some of the other coverage through the course of the afternoon. People are like, "Oh my God, look at all we have to go through everyone line by line." No, not a chance in hell that I am doing that. I'll tell you what. But we do hit some of the high points, and I think we'll do some of the defense today. Look, we know the hearing's not till a week from today.
Yeah, and we know how to cut through the chase. Thank you, Black Butterfly. I love the show. I don't comment much, but tune in every episode. Thank you.
Appreciate that.
Thank you.
So we'll do some of the defense today. We'll do some of the Commonwealth over the next couple of days. I do find it interesting, and I'm not perfect on this, but my gut is after looking at all the Commonwealth, there's nothing new from the last time.
Right. Unless the contents.
I might have missed something.
But the motions themselves seem to be the same, although some of the contents may change, and maybe some of the argument may change, and we can talk about why I think that's a possibility. Hi, Disney Nerd again. I think I said that. Missy, of course, is here as usual. We always thank her. Jason Hodges, hi everybody, hi. Let's give you
so there's a lot of scrambling around, and I just want to point out that we're not going to scramble. We're going to take some time. Not a crazy amount of time, go through the high points of the defense. We'll hit the prosecution, Commonwealth over the next couple of days. And then we'll be there next Tuesday. Nobody else is going to be there. So we'll be there when this is all unfolding. So, hopefully that works for everybody. Not only do we have to talk about the media protocol, which we haven't done. Yes.
We have to talk about, and we will at the end of the show, Mark Bederow's letter on Aidan Kearney, because for our week, for those of you that plan, Aidan's going to be on our show tomorrow night. We're going to be live at 9 p.m. So take a little afternoon nap.
Right. No Joe Biden schedule for you tomorrow.
Stop being political with my president. Okay. And then Thursday we're going to be on live. Friday we're also going to do a show. We're going to actually do more of. We're going to go through these and do them right. We're not just going, oh, look at this. What does this mean? We're going to try to take a couple of them tonight, do them a couple more Thursday, a couple more Friday and Monday, and also answer your questions that we've been promising you that we'd answer on this case if we didn't get them. So that's our plan.
We have a
and Michael will drive in his car. He's going to drive on St. Patrick's Day in his car, and he's going to go where?
Tuesday's going to be a busy day because
right. Where and you're going to go to Canton and Dedham and tell everybody what you're going to be doing there.
Well, in the morning, both matters are underway at the same time. Basically, by that I mean the Karen Reed matter with motions and limine arguments, but also the Aidan Kearney and his new arraignment on the crazy pizza closed circuit TV count of witness intimidation, and more importantly, and we'll talk to him tomorrow night about this. It's a separate court, but more importantly, they could revoke his bail. Remember, he's out on bail. He spent 60 days in the joint. Well, it was jail, but joint sounds more, So
Sounds
he's in there for
more
60
Vince
days
Agnew-like,
that nobody
Edward
wants
G.
to do.
Robinson-like.
Yeah, nobody wants to spend time behind bars, I'm pretty sure. So he does 60 days. That's 60 times as much as Karen Reed has spent, and she's up for murder. But anyway, so he does that, and then they let him out on bail. But one of the, the conditions of that bail is you don't get in trouble, right? Well, if this new charge is pursued and they use that, they could use that to violate his bail agreement and put him back in jail. So
Yeah, unbelievable. I hadn't really followed this case at all. We were at Law and Crime, we were doing it, but I hadn't followed the ins and outs, and they kept saying Turtle Boy and Aidan.
yeah, me
Quite frankly,
either.
I didn't know who
Yeah.
it was, right?
I thought it was this kind of weird side issue, and well, now we can see it's deeply enmeshed in the Karen
Right.
Reed case, and
Right.
perhaps reveals the motivation of the Commonwealth. It's far more than I ever thought it was, and it's going to be great to have Aidan on tomorrow night where we can get into all of this to the point that remember, he's got some stuff coming up. He may not be able to tell us everything we'd like to know, but he's certainly going to be able to give us his flavor for things. And
Right.
I know. Later tonight, it is Tuesday, he's doing his normal live thing. He does Tuesdays and Thursdays. And he's going to read that article that I've not had a chance to read yet from the Atlantic Journal. Have you seen
Right.
that?
I've seen it. I
It's
saw
a big, long article.
Right. And it's behind a paywall, but I think on his website he has PDF'd it for those who are subscribers to him.
So so he's going to lay that out for his audience tonight, and then we'll talk about that a little bit tomorrow, because he liked the article. The guy, I guess, was embedded with him basically for quite a while to tell the true Aidan Kearney Turtle Boy story.
Yeah, it's interesting. It's interesting, and now I understand how he got the name Turtle Boy. I didn't understand that initially. I just thought that was kind of like, because of Law and Crime, we didn't really get into it like you and I have gotten.
Not on that.
It,
not
right?
that it was such a collateral issue. I never really got much into it. So
yeah.
But now we're in deep.
And not only in deep, I mean, I feel like this is almost my case in the way I have to read all these motions, because we owe you all responsibility. We don't want to tell you all like BS, right? We want to go through things and tell you what we really think, like we always do. Michael, a lot of times it turns out to be the right opinion, like in the Menendez brothers, right? When we went against the what people thought would happen, only because why? Because we're lawyers, like we're real lawyers, like we practice law.
I mean, we just have opinions. We don't go in with an agenda. We kind of evolves with the stuff, just like when you guys see it and hear it, you have your opinions too. Okay, so I wanted to just at first take a look at this. Is just a list. This is not the actual motions that were filed. This is part one of the list. Okay, so you can see that it's got. I think I counted up. Did I say 39?
39. You
total?
said 39, right?
And that's that. And I think they were done for the day. I'm not 100% sure if they were done at that point when I first looked at it. And let me see if there's another one here to flesh out exactly how many there are.
And they were filed by both the Commonwealth and by the defense. These are motions in limine. Now, what is a motion in limine? For those of you who
good time for that. Open up the justice served classroom. Yes.
Okay. That is a motion to prevent evidence or so-called evidence, whether it be testimony, whether it be exhibits, from coming before the jury for various reasons. Whether it could be relevance, it could be it's inflammatory, it could be it's not truthful, it could be it has no relationship to the case at bar. There's a number of reasons, but it's called a motion in limine, a limiting motion, basically, if you think about it in English instead of in lawyer talk.
I'm trying to zoom in on some of these just so you can kind of get a sense of they get a little fragmented there.
Yeah.
Here's just take a look at just in general. These are all Commonwealth motions, which we're going to get to probably in the next couple of days. Expert celebrate demonstration, victims out of court statements, blood draw, bad character evidence. And remember, you'll see this when we get into the Commonwealth motions in limine. The way they are phrased, you would think, as Linda just suggested, it's a limiting instruction, or you're asking the court, please limit X, Y, and Z. Well, the way they structure there, sometimes it's please allow.
Right.
Please allow. So what they're doing is it's kind of heading off at the pass, something that they think may be objected to. So instead of saying please limit us to A, B, and C, throw out the rest, they may say please allow D, E, and F. right?
Please limit the defense from doing.
Yeah, that's
X
effectively what they're saying, but they're doing it in the
so that
context
we
of let
can't.
us do this.
Right. But we'll
Uh,
go to the first one. The first one's just a real simple one. It's kind of easy.
okay, help
on
me.
it.
Which one is it?
It's number 1, and it's in no particular order.
No
okay.
particular
Well,
order.
I can read it. Commonwealth's motion in limine.
Oh, you're going to jump to the Commonwealth. Okay, all right.
I'm only going to jump only, and then you can go to starting the defense. Because this is kind of like where trials begin. To appoint a court stenographer. Okay. It's such a basic thing because they're asking that there as a stenographer, and we've talked about this. Nancy King, who is behind the cone, who was our stenographer when we did Hernandez. You have to have the court has to appoint that as opposed to being by a voice recorder, right? And I'm sure there's no objection to that. It's probably all agreed to. But just to give you a flavor of what in limine motions could be, and that's an in limine motion to appoint a stenographer and not have a voice recorder. Also, to prevent the identification of jurors and impound juror names during trial. So this is where we first begin. Juries, right? It's not so secretive as you may think. So I just point that out because it's a good way to start. Where do we start? At the beginning.
Yeah, and these are the ones that I call pro forma, because they are not going to be objected to generally. But if you don't do it, then it can come back to bite you in the ass because you didn't do it and you probably should have done it. Took me that long just to find the one you were talking about. Let's see if I can bring it up here just a little more.
And we're not even talking the substance. We're just
just the process.
Right.
Let's see. Look at there's one right off the top, and again we'll get into these in some more detail on the next couple of days. But this one here you can see on 3/11/2025 that was filed. It's actually filed yesterday, I think, but posted today to the docket. Commonwealth motion for protective order. They've already agreed on that. It's already done deal. So
right. Yeah, endorsed and so ordered. They were supposed to be filed by yesterday. We were all looking for them, right? Where's the motions in limine? Where's the motions in limine? And apparently there's a couple of them that may be sealed, or some of the may be redacted in terms of what's in them in some matter, and that probably took a little bit of time. And then, of course, they get entered on the court docket because we were like waiting for the 5 o'clock dump, right?
Yeah, and it did not happen.
And it did not happen. Yeah.
Okay.
Yeah. So, all right. So I'm going to turn over to you now that I'm going to close.
I was going to hit and miss some of the normal.
Yeah, I'm going to close the class. I'm going to close.
You close up the class.
Disney already said, "Wow, she didn't know the stenographer had to be requested." Yeah, in a lot of cases, a lot of places now you have to request actually the appointment of the stenographer.
And sometimes it's a money thing.
Right.
Sometimes it's who's footing the bill. Is it agreed upon to be split? Is the county paying for it? It's not. That is very different from location to location.
Yeah.
Okay.
Actually,
So this one
yesterday, Brooklyn just hit what we asked. It was actually yesterday was the deadline supposedly, but they looked like they were filed yesterday, and then they posted them on the court docket.
Yeah.
Remember, somebody's got to put all that in.
Right. So yesterday, at the end of the day, these guys dump this, and then the clerk's office is like, "What the?" We now have to put all of this in and give it all a number and da. So yeah, I'm sure everybody was very excited at the end of the day yesterday.
Yeah.
Okay, so we talked about this. This is not one of the motions in limine, but we hadn't talked about this media protocol before. So let's look at this just briefly here, just out of curiosity. And so they go through it just for structural purposes. Most things you're asking the court to do, or an order coming from the court, starts with the law. They start with the law. And then you get into how it applies to a given circumstance. So you see all these rules. Now, you may remember, we were denied a press pass.
Well, we're going to reapply. We're reapplying.
Idiot, so we can't do this crazy work.
No. Yes, you're reapplying, right?
Yes.
You're reapplying because under the rule under the rule they cite, we qualify. Okay.
Yes, there's no doubt about it. They violate their own rule, but it's their rules, so they can violate them all they want, and then it's up to us. They can challenge us to sue them. I mean, that's the next step.
Well, but we can go through that because we do qualify, and you're going to be there, so you might as well go hand in the application.
Well, it's all done through Boston. It's not done through Canton or Dedham. It's all through Boston. That's the judicial counsel up there that does the press conference,
Right,
press
right.
credentials. So yeah, they get the stuff, and they work in a back room somewhere where they never see anybody. And of course, my response when we were denied was not very pleasant. So I'm sure I increased our odds of being reconsidered. Anyway,
You have to know that Michael Bryant has won an Emmy, that he
yeah,
can be a
like
little
they give a
snarky
shit.
when you violate the
Anyway,
rules.
so yeah, just cruising through these, see if there's anything of any interest. They're all pretty much typical. You can't you can't record certain things. There's going to be the pool camera, media requests. This I do think is interesting, and this is handled differently. Look at number 6. Media requests for inspection or copies of trial exhibits shall be made on a form or in a matter prescribed by the clerk of the court. So they can be very controlling in terms of what the press gets to see as exhibits. But luckily, the clerk's office shall make reasonable efforts to accommodate such requests in a timely manner, subject to court operations. So it's known that the public has a right to these. That's the question is, how do they make it happen?
Yeah, there's one particular thing in here that I want to talk about, and it's number 5. I know you went to number 6.
Okay, let me back her up. Okay, gotcha.
Okay, you went to number 6, and why I say this is because it says that no person is permitted to record, transmit, or broadcast sidebar conferences between the judge and counsel, conferences between counsel, and conferences between counsel and the defendant at any time. That I understand, except the sidebar thing, it intrigues me. While you can't record it, what does the word transmit mean? Okay. Remember in ASAP Rocky, we reported that we believe that the judge in the courtroom, and we don't know if it was sidebar or not, had questioned the prosecutor as to whether or not, remember ASAP Rally, whether the prosecutor could go forward on ethics. Now, let's assume something like that happened here. In this case, does the word transmit, if there's a leak from somebody, mean that the media can't transmit that information of a leak?
You want my opinion? My opinion is, because this relates primarily to electronic transmission, that's the context in which it would be interpreted. Transmission by some sort of electronic means, not and then you transmit it or broadcast it. If it said it says or broadcast sidebar conferences, it's all about the electronics. It's not about publishing by way of, here's what we heard. Just my interpretation, because everything here relates to the electronics, microphones, cameras.
Well, I'm just bring that up because
so you think you get in trouble for that?
Yeah, because I mean, the way things are being interpreted in Massachusetts, it seems to be different. All microphones should be shut off during sidebar conferences. Yeah, you don't want accidental transmission, and of course, the jury can never be photographed. Now, what's interesting to me, and having actual experience in this, where is it that the camera is specifically says the jury shall not be photographed? I believe
it says it at least a couple of places. Let me see.
A couple of
here.
places. But it's like even accidentally.
It's number 8.
It's even accidentally you can't do it. Okay.
Yeah, and they're not even allowing cameras in during the jury selection process.
But
and again, that's always hit and miss.
Yeah, but I'm looking at where I'm just all of a sudden I had it highlighted, but now it turns out I have so many things highlighted that highlighting
it's all highlighted. So you'll notice here on 8 that they are allowing. It's kind of, I don't even know if anybody's going to show this or use it, but they're having a pool camera, both film. They call it film. Hello, welcome to the century. There's not a lot of film camera going on. It's recorded digitally. They're going to allow one of those and a still camera. And that's for, just for the introduction of the case at jury impanelment. But once they've introduced the case and the parties, everything gets shut off. So other than it being kind of an indication, here we go, we're starting, not a lot happening during that little moment.
Yeah,
that is going to be allowed.
Yeah, that will be, which is good. But it does say that the camera operator cannot even accidentally accidentally record the jury. Now,
yeah,
we've seen
it happen. We've seen it happen
in Hernandez. All right, I actually have the screenshot because we had to deal with it. Okay. The camera operator got initially removed. Initially, none of us knew what had happened because as he's putting the camera down, as he was putting that, totally accidentally, it grabbed a portion of the jury in the jury box as they were leaving, right? And he's just moving the camera down so it doesn't do that, okay? But I guess his arm kind of hit it, it kind of swung, it grabbed it, it broadcast for a second. And then he was allowed in because afterwards, after being not allowed in for like a period of time, because it was clearly accidental. So I don't know how you can say, well, the camera operator can't accidentally record something when it's accidental.
Of course, that's so stupid.
Yeah.
Yeah, I mean, I get it. It's to reinforce the importance, and there is nothing more important because that's, if that happens enough, you're going to see cameras in the courtroom less and less often. But yeah, I mean, it's not like I intentionally, accidentally did it. I mean,
Right.
if somebody's, has a problem, they trip, fall, whatever, and it happens, that's an accident, and I don't know how you can prevent that.
Yep. It's
Okay. So is there anything else in here you like?
No, it's just the same thing goes with the pool camera shall manipulate the camera's zoom or focuses to reveal accidentally or otherwise. That's the number 5. The same 5 documents or of attorneys, the clerk of the court, or the judge, or any of the documents not admitted as trial exhibits or not published to the jury. But again, if you accidentally do it, I mean, in Hernandez, we had, because they had like the screen, and then there were screens that are right next to the jury box, and there were screens. We had the exhibits on our screens on our computer, and so if the camera looked at the witness, it saw all the screens with documents on them. I mean, it's just the way it is. I had one war story. Somebody wrote an article demeaning me for representing Aaron and saying, gee, and all I had, believe it or not, my screen was the screensaver by Apple. It was the normal mountains or whatever they would have on a screensaver. And it said, the poor people that got killed, which of course we always treated the victims with respect. We tried to, right? But doesn't Miss Kenney Baden, she gets to take a whitewater rafting trip, because I had written about this, with her son in these mountains, right? And these poor people their families are destroyed, demeaning the job of a defense attorney, not realizing that it was a screensaver. And my trip whitewater rafting with my son had been like 20 years earlier, right? That I had written about somewhere. So, people get a little crazy about this stuff.
No.
Really?
Really?
Not our viewers. Our viewers are informed.
Look at number 9. At the very end, it says, court prohibits any person from taking photographs, filming, recording, or broadcasting events occurring outside the courtroom in other areas of the courthouse. That's very different than, remember when I was in Florida for Sarah Boone? We did our live from the hallway, right outside the courtroom. So, of course, Massachusetts ain't Florida. That's for sure.
I guess unless the person, but even right now you have cameras. I guess you don't have you have cameras like your iPhone, but they're not broadcast cameras outside the courtroom, right?
Well,
this is kind of confusing because people coming out of the courthouse, how could you? I'm a little confused by this.
I think if you whip out your cell phone anywhere, they treat you like anybody else. It's a camera. It's a camera.
If you whip out your cell phone, like in Los Angeles, that's why I assume Joe Tacopino's team and ASAP Rocky had to get permission for that one photograph with the judges in the background in the courtroom, because they'll take your phone away. They'll take your phone away and go through it.
Yeah. Oh, it's militant. Yeah. When I was doing Daniel Penny, they were really like I had mine out to turn it off, and the guy was on me in a minute. I'm just turning it off. Please don't pull your weapon. Yeah.
But we wanted to go through this order because.
You want to go through it? I just
no. We wanted to go through it in some of the high points with you, even though it's a kind of a standard order for Massachusetts. There are things in there that are done differently. And there are things that, have happened, and we wanted to explain to you, like the word accidentally showing something, and how you prevent that is kind of...
Well, you never know with all that filming going on. You have to be very careful. Okay, so let's start with, I'm really taking these in no particular order, just those that seem kind of interesting and maybe instructive. This is the Karen Reed motion for attorney-conducted panel voir dire. So, why would you ask for this, and why is it important?
You're talking about panel voir dire?
By the
Is it-
attorneys.
It's important because usually what happens in most of these cases is the judge just asks the standard questions, right? And they don't go very far. Like, you ever tried a case in federal court? Like, do you have any biases? No. Okay, thank you very much. Have you heard of
Can
any?
you be fair? And
can you be fair? Yes. Have you heard of any relationship to the parties here? No. All right, you're on. But
Yeah,
the
you pass.
attorneys like to go a little bit further. Based on what their trial consultants have told them, and ask questions that are a little bit more probing. So, especially in a high-profile case, it becomes very important to try to ask for, even in places that don't have attorney voir dire at much greater length than is normally allowed, if allowed at all.
So here's what they're asking for. Ms. Reed asks that they be permitted to talk about whether previous experiences with the jury system or criminal legal system existed, characteristics of whatever the case was there media attention, personal characteristics or concerns of the jurors that would make it difficult for them to be impartial. And that kind of question could come from the court. Whether prospective jurors have strong personal beliefs about operating a vehicle under the influence of alcohol. Whether prospective jurors have been involved in or have close friends or family members who have been involved in domestic violence relationships, which I think is interesting because I think that suggests that questioning suggests it's a bigger component to this case than I think it is.
And why?
Because there's, I mean, yes, we understand there's evidence of some squabbling between the victim and the defendant.
Yeah.
But it's not a spousal abuse case. It's not a domestic violence case as we might normally consider them. But so I think if I'm on the jury or I'm a prospective jury member and I hear that, I'm going to start thinking it's got some of those components. And I really don't think this one does to that degree. Whether jurors or anyone close to them have been involved in a motor vehicle crash, well, that's got to be everybody, right? Jurors, victims of violent crime. Prospective jurors understand they can be impartial in light of the procedural protections afforded defendants. In other words, that's the old cloaked with innocence type of analysis, right?
Right.
You realize Miss Reed is totally innocent as she sits there, So, so that's, again, it seems like something simple, but you got to ask for it. And with Judge Bev, I don't know, I'd have to, set the Wayback Machine, Mr. Peabody, to remember exactly how restrictive she was first time around.
Well, Judge Kearney does know about jury selection, though, but isn't there an added component here? Because there's been a lot of media and a lot of stuff that's happened. I mean, when we first got into this, right, as when we had Will the Glare on last night, he said he just thought it was a regular case, right? Somebody hit her boyfriend, killed him, and he assumed that she was guilty initially until he got into it. But now, after the trial and all the other stuff, isn't there more that she has to question about, Michael?
Well, we'll see if she does. I mean, obviously, we've had trial 1. We've had all the run up to trial 2. I don't know. I would say the awareness of the trial is exponentially higher. It's not just, what's that Karen Reed case? It's like, can you believe that Karen Reed case? Everybody has some impression about it. So, yeah, I would like to see her press a little bit or allow the attorneys to press a little bit. But who knows? I'm hoping that's and it should be in the super large courtroom so that I can sneak my way in there. Unless, of course, I get my press pass between now and then. Yeah,
it's really interesting, too. In Massachusetts, generally, they bring the panel into the large courtroom or, Boston's a little different because you can use the basement area. But they usually, and I don't know if they did this in Dedham, walk the defendant through the impaneled jurors who are already seated up to, and then they turn around with their attorney, say good morning and all.
And they introduce everybody. Right.
Introduce everybody. But it's interesting to walk through if she's going to do it that way. And I don't know whether she will or not.
Yeah. You'll see here that, to your point, they reference, newspapers and news networks, Boston Globe, Boston 25, New York Times, Vox, NBC, CBS, Washington Post, to name a few. Yeah, because I would think that there's at least double that. I don't see Justice Serve TV on there. Okay.
Well, then that's because they're not looking very hard, because we're all around. Matter of fact, we come up now all the time because you go there. You've been there a number of times, and then you're going to go Monday night. You'll be there all day Tuesday. Yeah, it's really easy to go just for the trial and go for the opening statements, but you really get the lowdown of what a trial is about by being there on motion days and days that aren't like, oh, look at this, everybody's here, right?
Yeah, those are the what I call the Alphabet Network days.
Alphabet Network.
They show up for the opening and they show up for the verdict.
Yeah,
that's our coverage.
Or as they said in the play I saw the other night, Glengarry Gid Ross.
Oh yeah, was that good?
That was fabulous.
Because I love. I mean, David Mamet, who wrote the movie based on your Phil Spector story. I mean, he is such a great writer, and that I've seen both the play and the movie, and it's amazing.
And with this cast, Kieran Culkin,
an interesting cast,
and Bob Odenkirk, and you've got Breaking Bad and Better Call Saul.
That's Odenkirk.
Odenkirk and Bob. Oh my gosh!
Who is the third person?
I got a time like this. Keep
Kieran Culkin. I can picture because they've been doing a lot of advertising.
Bill Burr.
Which is interesting casting.
And then you had John Piricella, who was in the David Mamet movie. He always played Helen Mirren and me. The sidekick drove her around and all that kind of stuff. It was great. The casting was just phenomenal, and it was a huge theater. It was the Palace had been redone, but ABC was always be closing. So maybe, that when you think about it, isn't that what the attorneys should be doing, right? In their argument, they should always be closing. They should.
Yes, ABC, always be closing.
Always be closing. Wow,
yep.
It came to me.
Is that going? You were seeing kind of a little preview kind of thing, right? So
we saw the last dress rehearsal, right?
Yeah, so it's up and running now?
I think it started previews tonight. Starts previews.
Nice.
Cool. But it's absolutely worth seeing. First of all, it's a great play.
Yeah, it is. Yeah. It is.
But I'm going to have to talk to David about that. Always be closing. It has a different viewpoint when you're thinking about it in terms of the law. Okay.
Okay. So we're moving on from this one, are we? Are we good? Any further questions from counsel on this one?
No, I'm. You're the lawyer, and I'm the appellate judge.
Well, I've disappeared. Is that the way it is? Okay, then tell me, how do I turn this one off?
Because you're so good. You're so good. You can answer anything.
Yeah, if I don't know, I just make it up. Okay, so let's see what the next one looks like. I'll just pull it out of a hat here. And you mentioned this the other day, the demonstrative exhibits. What do they call them there in Massachusetts? So give us the backstory on that.
I guess in the olden days, they wrote on a blackboard with chalk, okay? And so the first time I heard of the demonstrative exhibits are called chalk. What chalk are you using, counselor? And you're not allowed, by the way, to use chalk unless there's a real special order of the court in your opening statements in Massachusetts. Sometimes you can agree, this will be this exhibit, that'll be that exhibit. It's okay if we use it, we kind of trade off. I don't know whether they have that agreement, but I know that they wouldn't allow us to do that in Hernandez. But again, when you hear chalk, what's chalk? Everyone's sitting around.
Who's got the chalk?
Who's got the chalk?
It made me wonder about, my proposed closing with the tail light and a hammer. I wonder if they would even let me. I would probably do it without asking, just to make sure I could get it in.
I'm not sure.
I have a feeling if I asked that it would be denied, and I'm not sure that's appropriate.
We had a demonstration, and we had bought an exemplar shirt in Hernandez to show how the bullet hole would have gotten in the body, and from the person that was argued was the shooter, which was not Aaron Hernandez. And the court initially denied us. And we were furious, came back and had to re-argue because it's a demonstrative exhibit, right? You're putting a shirt on somebody and you're having your forensic pathologist go through it. And the court initially denied it. They were they're so strict up there, but then the court did let it in. And it was very informative.
Yeah, I am so big on demonstrative exhibits because to me, it's you're entertaining that audience of 12, and how is the best way to make your point if not with that, visuals and demonstrations. So I would hope to see that. I don't know that we will in the defense closing some physical manifestation of that's the question.
You have to get an order because you see how there's an order for a demonstration of how
I
celebrated.
know for chalk. I know. But it seems to me there's perfectly good grounds to do that. It's based on the evidence presented and the arguments the defense is making that a body could not possibly have broken this taillight.
Right, right. And maybe the way
it's
to
argument. It's argument. It's not like you're taking that into your opening statement and saying, look, here's a taillight. Evidence is going to show that it takes a hammer to break it. No, you couldn't do that. That you could not do. But in closing arguments, you should be allowed to do that. So let me get a hold of Judge Bev. Work that out. Okay, so
Judge Betsy, Judge Kearney to me. I remember I teach with her, so to speak. I mean, I don't teach with her, but she's on the same.
Put in a good word or put in a bad word. Put in a word. Okay, so this is a chalk. This is some chalk.
Here's some chalk.
Defense wants to use it, and this I think is a great idea. Christina Hanley. Anybody remember Christina Hanley? One of the investigators who talked about finding glass fragments, pieces, something. But there was never any real demonstrative exhibit to explain to the jury where was it, how did it work, and so the defendants, again, this is generally not their witness, but the defendant wants to use a chalk demonstrative exhibit to help the jury understand exactly what she was saying, and I have to believe that the defense feels that this will, I don't want to say hurt her testimony, but in a way better explain it that doesn't support the prosecution. Does that make sense?
Yeah, because obviously you don't want to.
You're not trying to help the prosecution.
You don't want to have to ask for the glove to be tried on.
Yeah. Oh my gosh.
Okay. All right. Isn't that the same thing? You want to be able to show that whatever it is works against the other side's case.
Yeah. And so I think this is a great idea because it should, if the defense gets their way, reinforce. Look at that, 16 pieces of glass originating from 4 separate sources. Some pieces of glass came from the same source, meaning they were originally part of the same object. These are just references to the prior trial transcript.
Now remind everybody, he was holding a wine glass or some sort of.
Well, I think it was more of a tumbler, but okay.
Or whatever in his hand, but then the light is polycarbonate, right? The light is a plastic.
Oh, yeah, the plastic part. Yeah, so the only thing that was allegedly glass was the glass. And I know that at times it was called different things, but I think glass is, I'll get one of those for a demonstrative exhibit and then I'll smash it. No, I mean, I think it's like a little highball. I call it a highball glass, Well,
they do that in every wedding I go to, a Jewish wedding.
Jewish wedding?
You smash the glass with it's wrapped and then it's smashed with the foot, but there's a certain amount of force, right?
Yeah, I'm not sure how that works. So what's the purpose of that? Does you take a wine glass, you got 2 of them, it symbolizes their separateness, and you smash them together, and that symbolizes their upcoming divorce.
You wrap it in a napkin, and then it's a new beginnings. You break the old, and you begin the new.
I slipped that one in. You didn't hear me say that.
I don't know. Are you getting divorced? I'm Catholic.
Just ignoring me.
I'm not supposed to be divorced according to the Catholic Church, although they grant divorces all the time or something. Annulments, I guess it is. If you pay enough money.
See, here they have bottom of page 2. You see, they call each group of pieces is called an item. These items are item 3-2, the base of the cup recovered from the scene. So there was some confusion even in the way they described it. So certainly some demonstrative exhibit is going to help. They talk about finding glass on the bumper. They find glass, and again, your buddy, Trooper Kenney.
My buddy. Just because on the first day I thought he was a really good witness, and on the second day I was like,
right.
Why was I wrong?
My favorite really bad witness. A single piece of glass from the scene by Trooper Proctor. And again,
you bring in Trooper Proctor.
Yeah, we'll get to see how that works.
Can we talk about him a little bit? And we're going to go through him more in great detail. And I know I'm supposed to be doing the defense, but the prosecution wants to, and when we talk Thursday, I know we're going to really get into this. They want to limit all of his statements that go to bias and stuff. You remember all that stuff?
Oh, I remember.
I don't even want to repeat it. Some of it was so horrible, right? Now, obviously they tried to do that the first trial, but he was a witness in the first trial, so he had to come in and cross-examination. This, to me, now may be the one area that may be different. And again, we're going to get into this more on Thursday night, so you've got to come when we do all these motions. What if they don't call him as a witness? Is the defense now not allowed to get into that because all the other troopers have to say is, oh, I didn't receive any emails from opinions that Trooper Proctor that affected my investigation? Then does it become not probative and therefore it does not get allowed? I mean, I can see that happening.
I could too. And I mean, it just opens up the bigger question. If you're Proctor free, how do you fill in all the holes that he provided good or bad testimony about? So here's what they want to do with this chalk. For each individual piece of glass, the chart will include graphics next to the corresponding label based on which other pieces of glass that piece matched. So it'll be like, remember those old games, like when you're a kid, you match pictures with the statement about them, crisscross. So they'll do that so that hopefully in the jury's mind, it'll create a better picture of, I'm sure what the defense thinks is the absurdity of the finding all of these pieces of glass and where they supposedly came from and where they ended up.
Right. And after the fight about the cameras and the tail light that we can see, and the fact that everything about those cameras that we've gone into are a problem, to say the least.
So in their argument, sub I, the proposed, or that's one, I suppose, the proposed chalk is highly relevant. Whether any of the glass on the bumper matches the cocktail glass, okay, they're calling out the cocktail glass, the highball glass, or is from some different unidentified source and goes directly to whether the evidence in this case supports that Ms. Reed struck John O'Keefe or the cocktail glass in question. The relationships between the other pieces of glass are critical to understand the scene. Therefore, the chalk, which summarizes Ms. Hanley's testimony about this glass, is also relevant, given that the chalk provides much needed clarity in an otherwise complicated issue. So it's good. Yeah, I like the way they use the defense of the prosecution expert testimony. She's not really testifying as an expert as much as law enforcement, but yeah, right. She's with the state police. But they're using it against her, really, saying, well, oh my gosh, it's so complicated that we need to get this demonstrative chalk in to help explain it to the jury. I love it.
Yeah, no, interesting. So anyway, this is a pretty good flavor about what we have, and 39 of them. Okay, I believe there were about 16 of them that were from the Commonwealth, maybe more. If I look at my notes here, I think there were 16 of them from the Commonwealth. Okay, remember, one of them is actually a motion for attorney conducted, as you pointed out, the individual voir dire, and proposed jury questionnaire. We haven't even talked about what's in the proposed jury questionnaire yet.
Yeah. Do you have that? Did they release that? Because I wasn't sure.
I haven't seen it. We're going to see.
Yeah, I hadn't seen it.
We'll
either.
see if we can get it between now and then. It's got to be somewhere around, right? Because there was a first trial, so it has to be.
Yeah,
somewhere.
Yeah. Assuming they released it from the first trial, you're right. Yeah.
Assuming they released it from the first trial, right? I know. Yeah. So, and then the rest of the motions were by the defense. So, what Michael and I would like to do is go through all that on both Thursday, Friday, and Monday, along with a lot of your questions. And we wanted to give you a flavor tonight of what is there and some of the things that just jumped out at us and explain to you exactly what these are and whether or not they make a difference, if there's anything new, at least from the Commonwealth, and we didn't see.
I think you'll like this one. I'm going to take a look at this one. What time is your heart out tonight? Where are we?
6:58.
Oh, so,
right, 6:45.
Oh, that's your heart. Okay, so we're good. Let's look at this one. I think this is interesting on a couple of levels. Again, we're looking at some defense common motions in limine here. This one has to do with defense motion in limine to prohibit testimony regarding funds paid to experts for purposes of voir dire. So we know the factual background here about these different experts. Boy, are there a bunch of them. Luckily, Dr. Marie Russell got in by the skin of her teeth because it was a close call. After 2 days of Lanigan hearing, I mean, she's no
2 days of trial testimony.
She's no Dr. Crosby. You took a seminar in dog bite, you're in. Anyway, also Dr. Wolf, the one with the E. I think the other Wolf has no E.
Right.
Dr. Rensselaer. Anyway, these were experts that were paid. But what is the distinction here that the defense is looking to prevent the jury being told?
They don't want to be told about the payment after the fact, after the first trial.
So kind of like a result-oriented, like here's
Right.
here's.
Hey, their opinion should come in because they were paid by the government. They were governmental witnesses, and then it shouldn't be diluted here in juries in the jury questioning about whether or not they were now paid by the defense afterwards, especially since the line item hasn't been released.
Yes, you're right, and we've heard just a touch of it during the argument that was made. Phone call, 45 minutes, whatever. So they're trying to.
It may be there's going to be a motion, an eliminating motion, a hearing, right, as to what the understanding was, and therefore, if it's more prejudicial and not probative, it should be kept out, right?
Yep, and I mean overall, that's the overriding balance the court is supposed to strike: prejudicial versus probative. Everything in a trial should be probative, otherwise it's irrelevant, immaterial what's doing there. So it has to have some probative value, and everything also has some prejudicial value. Why do I want to get it in to support my case if it isn't somewhat prejudicial? The real question is, where does that balance fall? Sure. And that's a judge call, and we know with Judge Bev. Yeah, but there's a thumb on the scale.
Why should the jury hear about it? Why should there be anything in opening about it when indeed the government had paid them and had hired them? Is going to be the argument, and all that does is dilute the issue for somebody that may have said, "Hey, my people don't get sent out there to go free. You bill for your time. You spend 2 days there, you bill for your time."
I think the interesting distinction they're making here is, and they want to do this because if you use all of the monies, including those for voir dire of the experts, right? We're talking about voir dire of the experts. If you add that in, it inflates the money paid to those experts. Therefore, the impression to the jury is, oh, you paid more than anybody else. You got the testimony you were buying, right? And they're trying to prevent the jury from hearing about those expenses as whatever retention cost there was. We're not going to let you pile on those voir dire fees because they're irrelevant to the testimony.
Right.
That's the argument. I don't know how this one's going to go, to be honest with you. I don't know.
Yeah. I don't know. We'll see. Usually what I've seen so far is, now that I've been following it, is like the rulings tend to go against the defense right now.
Well, if you look at the guts of this, it really relates directly to Judge Bev's grave concerns, because it's related to the expert acquisition of reports from the federal third-party ACA experts, right? And that's what she was most concerned about when they were retained, when they were hired. What did they say in the first trial about that?
She felt that the wool was being pulled over her eyes and the jury's eyes by saying they were independent experts when you, Mr. Jackson, you knew that they weren't, which is not necessarily true.
Yeah,
not necessarily true, not true. The way it's come out.
Yeah, and she's so sensitive about that for whatever reason, it could impact the decision on that one. Right. Okay, remember there was a jury view first time around. Remember that? So, in whenever it was, late April, early May, everybody treks out to 34 Fairview. They have the Lexus SUV. Where'd it go? I know you're around here somewhere. Oh, there you are. They have this parked, at the curb with the taillight missing. They have that module is removed. So it's just sitting there at the curb. I don't know if it was really represented that was the specific location, but I think it was there because the jury could then see the vehicle involved, the relative spatial orientation. And of course they could see, the taillight module was missing, which at that point really wasn't relevant. But they're going to come back. They're going to do it again. It looks like they're going to do it again. I can't imagine why they would not.
You basically read a jury view without the car. You went to CF McCarthy's. You went to the waterfall. You went to the location that John O'Keefe's body was found. The only thing you didn't go, I guess, was the police garage to inspect the cameras. But I think you'd get arrested if you went there.
To where?
The police. I call it the police garage to inspect the cameras.
Oh yes, to see the Sally ports. Yeah,
to see the Sally port, right?
Yeah, right. That was not on my tour. No, did not get that. So here you have this is again an example of where a motion in limine is really asking for something not asking to limit something. So the defense is looking to take that view of crime scene. Pro forma, yes. Necessary, definitely. And you never know. We do have some suggestion in this case. Why wouldn't you? You did the last time,
Right.
but you better ask for it.
Right. And it costs the government money. It's really interesting to go on a jury view.
And it's interesting. There's law in Massachusetts, I guess, that determines whether or not the court is not required to invite the defendant, but can. And again, part of that is because of the cost and the custodial issues. Probably different and an easier call when the defendant is not in custody, not incarcerated.
Right. The defendant in our case wasn't going out to in California with Specter. Of course, he was there. He was in his own home. Hernandez wasn't going out with the on the buses with everybody to the scenes. It's different. I think it's different, and that's why you have it's a permissive as opposed to mandatory.
No, I think jury views are great in general, and the defendant obviously I think should be there. Allowing the impaneled jury to view the crime scene located at 34 Fairview Road will be particularly useful because the lawn appears to be much more expansive. See, I disagree with that. In photographs, I do agree. I'm sorry, I read it backwards. It is much more expansive in photographs than it does in person. I would totally agree with that. It's kind of like, when you go to a place you haven't been for, you went when you were a kid, and then you go back as an adult.
It's
you go, oh my God, it's so tiny.
It's so tiny.
And so I think you do kind of get that impression. It looks like if you were to look up Tract Home, TRACT, Tract Home, Anytown, USA, that's what this house looks like. That's what this yard looks like. It's just cookie cutter, lovely little community, nice little neighborhood, but it's, you're not going to be wowed by it.
Yeah, it's totally different. It's just like when people went to Florida, like there was a hotel called the Fontainebleau, right? And it was supposed to be like gigantic, and then you saw pictures of it 10 years ago, and it was with all the massive hotels. It was a tiny little thing. It's your perception of what you think is large is different, and it's important to see it in perception.
I think it is.
Look, we tell attorneys always go look at the scenes. Civil or criminal case, you got to go look at the scenes. You can't. Just
and I can't say that's true in every case, but in this case, I really think it's important. I do like this phrase they took out of Commonwealth versus Gomes. It being permissible merely to point out to the jury marks, matters, and things. So you're going to check out marks, matters, and things. That's a good idea.
Matters and things. That's a really good idea. Well, Michael, I think since we're going to be talking about this in great detail, we've given a flavor. I think we should talk about what's going to happen tomorrow night, and in anticipation of that, an affidavit that was filed by Mark Bederow.
That is a good idea. I'm
glad a very interesting issue. And I say that because somebody pointed out that since you were passing the pizza parlor, D&E Pizza, Candy Temple says, Michael, I hope you weren't talking in front of D&E Pizza, LOL, because they have a Wise camera, right? Which is kind of like, it's kind of like a Ring, and it's like in a corner, and apparently it doesn't have, how you can go into your camera settings if you have a Ring and you turn off the sound, like I try to do, unless there's a Ring, somebody beats the doorbell, because I was concerned that it was a federal wiretap violation to be.
And let's talk about some of the different what a two-party and one-party state will be. When I was working at Extra, we used to do a lot of undercover stuff. California is a two-party state, and that means, so is Massachusetts, you have to have the approval of both people to the conversation to record them. Now, makes common sense, right? But if you go to Nevada, if you go to New York, if you go to, and I used to fly to New York for our Extra offices in New York, because then I could do it, or I'd go to Vegas and we would do stuff there. One-party state, which means as long as I'm okay recording it, I can do anything I want, and I can capture anybody I want. Well,
without getting the approval. You have to approval.
Yeah, it's a one-party state. I'm the party, and so I can record you. It seems almost ridiculous and a violation of privacy, but if you're out in the public, watch what you say. So in this case, it's a two-party state. You've got the camera mounted on the corner of the building, shooting across. The one that Aidan is playing to, I'll call it.
Well, he says he wasn't playing to any. He's playing. He said that he was playing
to the store in general.
No, he was playing to the window. Yeah, he was playing to the windows.
So we'll talk to him tomorrow about that.
Right.
But the one that he was facing, I'll put it that way, intentionally or otherwise, doesn't have audio. the one up on the street corner, outside the building does. So if you're walking down the street, I tell you that McCarthy's has the best steak ever, or whatever you say, that's being recorded without your permission, right?
Yeah, if you're planning a crime, if you're or you're having a fight with your spouse, or if you're just talking, it's getting recorded and you don't know about it because there's not even a sign that says, you come up to my property at my cabin, it says, place is monitored by cameras, right?
Yeah.
So that you're on camera.
So here's the very clever argument being made via letter to Chief Rafferty, Helena Rafferty, Chief of Police. This comes from our friend Mark Bederow, who of course was denied pro hac vice in this case, and sends the note saying, I represent Aidan Kearney. Formal request for the Canton Police Department to commence a criminal investigation into Mr. Albert, that's Chris Albert, owner of the pizza shop, D&E, for apparent violations of, there's the code section, interceptions of wire and oral communications, both generally and regarding the interception of Mr. Kearney's oral communications outside last Tuesday on the 4th, as detailed below. So he's basically saying this is a crime, Mr. Albert, and the chief of police should be looking into this, because every time somebody walks up and down that street and says something captured by that camera, that's a violation. It's a wiretap violation. What do you think? I think it's a very great argument.
I think it's a great argument. I mean, as a lawyer, that's the kind of argument I would make. I think it's a great argument.
And then they quote
especially
here,
since you have a camera that doesn't have the sound on it.
Right. And they quote here, I think they'd be much better off if the one inside had audio and the one outside did not. I think that's a different call. Mr. Albert alleges that on March 4th at approximately 10:20, he listens, I like this, from the safety of his home to surreptitiously recorded video of Mr. Kearney addressing Mr. Albert and his son Colin about the Reed testimony. Albert alleges that he was very upset about Kearney's statements, although not relevant to the issue of whether Mr. Albert is in violation. The video depicts Mr. Kearney facing an interior camera rather than the audio-enabled exterior camera, which is located at the far end of the property.
Which, counselor, if I think that you have to have a two-party state to record, so I don't think I'm being recorded, I don't even think I'm being heard, and I'm mugging and doing all this stuff, where's the intent to affect a witness, right?
Well, yeah, that's a whole different argument, and I can't wait to get into that with Aidan tomorrow night, which is this is a good jumping off point for that. We're going to be able to do that. We'll get into Mr. Bederow's letter with him. I've also got a couple of flashbacks of some of his fine work from a year ago when this case first hit and he got into the trouble that he did. He was arrested a year ago. We'll preview what's coming up next week with his hearing. We got a lot to talk about with this guy, and we're starting at 9. So,
9 p.m. So it could go a while. Okay.
It could. Yeah. We're not shutting down. This could be a marathon. Yeah. This guy goes and this is one of the few times I might just say, you're going to have to stop us because we're going. So hopefully you join us for that. Should be quite fun. I'm going to let you go now. I know you got things to do.
I know, but before I go, I did want to say to Shy Gal, yes, every time I hear Linda talk about Aaron Hernandez, it just breaks my heart. Breaks my heart too.
So sad.
I have his letter on my computer that he wrote to me on 4/18/17, which is the night he killed himself. So it absolutely breaks my heart. And again, no one but me and law enforcement has ever seen it. As a matter of fact, we never got the originals. We only got copies from Massachusetts law enforcement. So that's something else that about complaining about Massachusetts law enforcement.
Man, bummer. Thanks for bringing me down. Okay.
Yeah, I'm sorry about that.
All right.
But I'll bring you up. You and Emmy Award winner, you did a great job putting this together. That's my partner. That's my partner who will be in Canton.
Thank you. Right back at you. So I'm Michael Bryant. We'll see you next time. Try to do the right thing.
And I'm Linda Kenney Baden. Together we are Justice Served TV. Please hit that like button before we go. Let me just give you a second. Well, hit that like button, all of you that are watching, because that gets us into the algorithm and gets us pushed out there. Also subscribe. We're free. You don't have to pay us anything to subscribe. And you've done a great job. You put us over 6,000 subscriptions right away. And also share. And then hit that notify button, and you'll get notified every time we're on the air, like 9 o'clock tomorrow night. See you then.